what do you think of the argument that from the Trump lawyers that he cannot be held criminally liable for anything until after convicted by the Senate, not just impeached by the House, but convicted by the Senate? And then they brought up the hypothetical, as you spoke of earlier. What if you order people to assassinate members of Congress?
Right.
Can you still not be held criminally liable? And Trump's lawyer said, no, not until we are first convicted in the Senate. What do you think of that?
I think that's a quite aggressive argument. I haven't studied that particular argument deeply, as you may know. I also filed on behalf of former Attorney General Meese and some other people a brief in the U.S. Supreme Court and in the D.C. Circuit on the question of whether Jack Smith has been validly appointed.
This is a great question. Yeah, do you mind laying this one out for us? Because Jack Smith is the guy who's prosecuting the special counsel, right, against prosecuting Donald Trump. And your argument is he's not even constitutionally eligible to do such a thing.
That's correct, because he exercises the authority of a United States attorney. As you know, there are every state of the union and in some places multiple different districts within each state have a U.S. attorney that's appointed by the president and confirmed by the Senate. And under the regulation written by former Attorney General Janet Reno, under which Jack Smith was appointed, he is, under that regulation, given all the authority of a U.S. attorney, so that he can basically operate nationwide to prosecute Donald Trump, and he can force everybody in the Justice Department and the FBI to cooperate with him if he wants, and all of that. So he's exercising the authority the U.S. attorney would normally exercise, in fact, even greater authority than a typical U.S. attorney is able to exercise. And yet he's never been appointed by the president and confirmed by the Senate. And the appointments clause of Article 2 in the Constitution says that officers of the United States have to be nominated by the president and confirmed by the Senate before they can operate. And there's a long history and tradition of exactly what does officer of the United States mean. It doesn't mean anybody who's an employee of the federal government, but a person who exercises what the law calls substantial authority under the United States is considered to be an officer of the United States, and that kind of person. And the framers were very deliberate about this. They wanted to be sure that Congress had adequate control over the kinds of high-level offices that any president or any administration would create, and who filled them. And so they wanted to be sure that if somebody was serving as an officer of the United States, that was an office that was defined by Congress in a statute, number one, and number two, that the Senate at least had an opportunity to weigh in on whether that person should serve in that role. And obviously none of that is true with respect to Jack Smith.
So the argument is that Jack Smith has as much authority to prosecute someone as you or I do, or Taylor Swift does.
Exactly. That was our final line. He has no more authority to prosecute President Trump than Taylor Smith or
Taylor Swift. Oh, you would have gotten some headlines if you actually used that line. That would have been a good.
Yeah, we did. Actually, and it got some headlines.
Oh, did you? Yeah. Oh, I was joking. Oh,
yeah.
I didn't.
No,
it's great. I thought you were joking too.
Thinking alike.
That's beautiful. All right. So last question for you, Gene. I'll let you go on with your day. Gene, you're being so nitpicky.
Yeah.
Does the court ever come back with that argument, that rebuttal? Like, you're getting in the weeds here about article this and that and intent from Janet Reno. Lighten up, Gene. He's fine.
Well, fortunately, we have a Supreme Court in which I think all 9 of the justices understand the importance of enforcing the terms of the Constitution as it was written, at least to the extent that they can discern what it means. And there's some phrases, like some words in the Constitution, like the word insurrection, that are not self-defining. And so they have to so they have to try to determine exactly what those words mean. But fortunately, all 9 of the justices, I believe, take the words of the Constitution seriously and strive to apply it because they understand, as I do, that the Constitution is not just the legal foundation of our country, but it's also the moral foundation of our country. And, as the Declaration of Independence says, all governments derive their just powers from the consent of the governed. And that's the only moral basis in our system for exercising governmental authority over somebody, is that they impliedly consented to it through their representatives in Congress, or in the case of the Constitution, their representatives who wrote the Constitution and then ratified it. And so all of us have been deemed to consent to the Constitution. And so as a moral matter, we've said, okay, you can, if you act in accordance with the Constitution, you can exercise governmental authority against us. And we're okay with that as a moral matter because at least our predecessors consented to it. But if you try to exercise governmental power in a way that's not consistent with the Constitution, nobody's consented to that, and therefore it doesn't have a moral basis. And so I think that's one of the reasons that all of our 9 justices are pretty serious about at least trying to apply the terms of the Constitution to the problems before them.
Yeah, well done. Sorry, Gene, one last question. I keep hearing this word self-executing. Yes. Section 3 of the 14th Amendment is self-executing, which is a funny term. What are they arguing here, and do you think that's true?
The second point that we make in our brief, besides the president not being actually covered by Section 3, we argue, and I think we're correct about this as well, that even if the president were covered, he could still not be kept off the ballot unless he was properly found to have engaged in insurrection under some legal process that Congress itself has set up. And there is one legal process that Congress has set up for determining whether somebody has engaged in insurrection, and it's called section. I think the section number is. I can get it for you here. Section 2383 of the Criminal Code of the United States, which defines insurrection and says that people who engage in insurrection can be criminally convicted of that crime. And and obviously President Trump has not been convicted of insurrection under that statute. In fact, Jack Smith hasn't even charged him with insurrection under that statute. Wow. And so our point is that that if you are going to try to exclude somebody from the ballot, you have to do it pursuant to some mechanism that Congress has put in place for determining that they engaged in an insurrection. And nobody has even attempted to do that with respect to President Trump. And the only way in the law right now that could be done is through that criminal statute, Section 2383.
Those 2 arguments sound so rock solid. I'm grateful you posed them to the court. I'm sure the court will take them. Gene Schaerr, senior partner at Schaerr & Jaffe, LLP, former law clerk to Antonin Scalia, and argued many times in front of the court. Are you going to argue again in front of the court, or?
As soon as they grant one of my cases, I'll argue again.
Wonderful, Gene Schaerr. Great to talk to you, sir. Appreciate it.
They don't allow friends of the court to argue. You have to represent the party.
Next time you do, you have to mention Taylor Swift.
I'll try to work it in.
That's your challenge. Gene Schaerr, appreciate you, sir. Thank you very much. All right, listen, that's as rock solid as you could possibly get.